the show you were talking about, Eric? The rehearsal show?
The
What's that?
rehearsal, yeah. Nathan Fielder.
Is that Apple TV Plus or Netflix or what is that?
HBO.
HBO.
Yep.
Max.
Yep.
And is that the one where they rehearse everything over and over again?
Mm-hmm.
What do you think?
It's hard to explain. I think it's tremendous. The second season just wrapped up. It's about aviation safety. So once you guys get to it, I'm sure you'll really like it.
Yeah. I haven't seen it yet, but did you see an episode?
It's trippy. Yeah, you got to watch it. I've watched one episode, so
I'll check it out.
It's really good. So, well, welcome everybody to ATL. And what day are we in here? What day? Is it Wednesday?
Yeah, I believe it's
the
Wednesday.
Holiday throws me off.
Yeah, it's a weird week.
And I was traveling last week.
Yes,
I'm glad to be back. So
we're glad to have you back.
Thank you. Appreciate that. So, Keith, we have these Amicus Curiae briefs. Yeah. Everybody says it differently, but we've got these. What is an Amicus Curiae brief, and what's the purpose of it?
Amicus Curiae is just Latin, means friend of the court, and so somebody who has an interest in the lawsuit, but they're not a party to the lawsuit, the court has the ability to allow them to file a brief in support of a position. You see these a lot in the U.S. Supreme Court. People will file Amicus Curiae briefs, and in appellate courts. You don't see them so much in the district court level, the trial courts, but the judge can allow them if they want. And it's usually just a persuasive brief that somebody who has an interest in the outcome of the litigation wants to file to speak on an issue.
And are these people, do they have any particular expertise, or are they just interested in the issue? I mean, what is a person who's sitting around going, I'd like to file an Amicus Curiae brief? Why would they want to file one of these briefs?
Well, I think, and we'll get into this as we're looking at this brief, but a lot of times it's because it's a party who's concerned about the policy that will be affected by a court decision. And usually they do have some expertise in the area, and we'll see today just kind of what that expertise can be, or it can be a substantial amount of expertise. But usually and this is why you see them a lot in the U.S. Supreme Court, because people have concerns with what the court's decision is going to be, and how that's going to affect different policies throughout the country.
And there was two Amicus Curiae briefs here. One was from an individual and one was from these entities, which we'll get into in a minute. But I thought the entities one was more the policy brief, where it was talking about the overarching implications of 47.1. Am I correct in saying it that way?
I think so. And I think, the one that was filed by Elise Dorsey is probably a little bit more of a
anecdotal.
Yeah, kind of a story. Whereas the other one was really, in my mind, more interesting just because it was filed with a view towards the overarching policy of why this law even exists. And this law being California Civil Code section 47.1. And so, of course, as a policy nerd, I'm that way. I know you're that way. I think the policy brief was just a little bit more engaging for us.
So let's bring everybody up to speed here. We've got the jury pool joining us again. And again, 80% of the jury pool, I think, very reasonable people, and they get this. There's 10% on the left side and 10% on the right side, and they're the loudest, and they get a little crazy sometimes. But for the most part, I think most people are very reasonable on this case, and they're willing to look at both sides, even if they are for Justin Baldoni. The majority of people are probably for Justin Baldoni, but I think people are willing to look at this case objectively, and they want to hear the game called accurately. They don't want one side favored over another. So we've been trying to do that here. The comments sections get lively after our videos.
Yeah.
And so that's good. But let's talk just a little bit about 47.1 to bring everybody up to speed. So there was a law that was passed in California in 2023 that became effective January 1 of 2024. So
new law.
Not too soon after that is when, about a year later, we get a filing by Justin Baldoni where he files a defamation lawsuit against Blake Lively for her sexual assault lawsuit. Under 47.1, it basically says that if you make a legal, or if you make a communication, just a communication about sexual harassment or sexual assault or discrimination to anyone, quite frankly, and you do it in good faith, you don't do it with a malicious intent, that whatever words come out of your mouth become automatically privileged. Become privileged as long as it's in good faith and you're not being malicious, right?
And what does that mean to become privileged? Privileged from what?
Privileged, it protects you from somebody using those words against you.
In a defamation lawsuit.
In a defamation lawsuit.
So really what it comes down to is 47.1 says you cannot be sued for any communication. I mean, and think about how broad that is compared to our normal litigation privilege. So normally we're dealing with filings in court. Filings in court, you can say what you want. You can't be sued for defamation. This goes way beyond that.
It's any communication to any person, any entity.
Whether you make an official filing or not, you cannot be sued for defamation.
Well, you can be sued.
Yeah.
You can be sued.
True.
But you have an ace to play. You got a couple aces to play in that hand, right? And what does the 47.1 give you the ability to do? If somebody, let's just say, let's take it away from this case for a minute. Let's say that I've sexually harassed you for the last year and it's horrible what I've put you through. And you finally say enough and you hire a lawyer and you sue me for sexual harassment. You're my secretary.
Okay.
You don't make a whole lot of money.
Yeah.
You live in a small apartment. You've got a couple kids. You and your husband both work very hard. You earn every penny, but you're not wealthy. And I sexually assault you just continually. I comment on your dress and your clothes. It got to the point where I was getting handsy with you. I was touching your shoulders, making you feel very uncomfortable. I propositioned you to go to dinner with me several times, and you've told me no several times. You finally say, screw it, I'm going to sue this guy. You sue me, and let's say I'm a super wealthy business guy, and I've got a lot of money. I've got 5 lawyers that I can call at any point in time. You sue me for sexual harassment, and I get angry, and I go, how dare you sue me for sexual harassment? I'm so good to you. I've paid your salary. I've been kind to you. I've tried to give you, my odor, getting close to you all the time, and
your musk,
and my musk, and you're not taking it. And then I get so angry, I call up my lawyers and I say, I want to get Keith Davidson. I want you to sue him. I want to sue him from the beginning to the end. I want to bankrupt him. I want to cause him all kinds of trouble. And before January 1 of 2024, I could do that.
Yeah.
In California.
You could file a defamation suit because let's say not only did I sue you, but maybe I talked to a group of friends and told them what was going on before I filed suit.
Right.
And so you said, oh, those communications with the friends, that's not a court filing.
Right.
I'm going to sue you for defamation.
Right. And I sue you and I put you through the paces.
Yeah.
I mean, I make you answer voluminous discovery.
Depositions.
I make you sit for a couple days of deposition. I then start taking your friends and family's depositions.
Right.
And I put it to a point where you finally say what? What do you finally say?
Enough. I give up. I'm going to withdraw my lawsuit.
Yeah. And then your best friend Shelly, who watches you go through this, she's experiencing the same thing. Does she file her sexual harassment lawsuit?
No, it'll have a chilling effect. That's
Why?
The concern. Because she's seen what somebody else went through and she's like, I don't want to go through that. So I'm not going to raise a concern. I'm not going to come forward and complain about it.
So how does 47.1 fix this?
2 ways. So number one, it allows somebody who has had a communication of sexual harassment or filed a lawsuit, if they're sued for defamation, they can go in on a motion to dismiss, as we've seen, and get the case dismissed early on before they have to do all the discovery. Now, it does have to be a claim that's made without malice. So there's a little bit of
the sexual harassment claim, not the defamation claim.
No, the sexual harassment claim has to be or the communication has to be without malice. So there's a little bit of wiggle room for a court to look at maybe an extreme case and say, I'm not going to dismiss an extreme case, but it has to be way extreme.
What's the source of that malice, though? Is the source of that malice, somebody doing something bad over here that has nothing to do with a communication, and then later on they communicate sexual harassment? Can we then say, well, that malice over here applies to the communication of sexual harassment?
No, remember, malice is at the time I made the communication, I believed it to be false, or I was reckless as to whether it was true or not.
Okay.
If I believed it to be true and I had a reasonable basis for thinking what I said was true, which, I experienced it. I think this was true, what you did to me. It's not malice.
Okay.
Even if I said it to people who I was hoping would somehow, harm you in some way, it's still not malice. Malice comes back to, do I think that it's false at the time I say it?
And you're still saying it.
And I'm saying it anyway.
You're lying.
Yeah. So that would be malice. So if you don't have that, then the first line of defense for somebody in my position is you would file to dismiss the lawsuit. Second line of defense is you get all sorts of damages. So you get attorney's fees. So if the case goes forward, let's say the court says, okay, I think there's malice here, I'm going to let it go forward, but you lose and I win, I'm going to get all my attorney's fees paid.
I'm going to pay your attorney's fees.
You're going to pay my attorney's fees. You're going to pay me for treble damages for all the abuse that I went through during the lawsuit.
Okay.
And you're going to pay me punitive damages.
Potentially.
So And remember, all of those things are not normally what you get in a lawsuit. In the American system of justice, each party pays their own attorney's fees, whether you win, lose, or draw. There's exceptions, like if you have something in a contract, but by and large, that's the way it works. So this law turns that around and makes a huge financial sledgehammer to anybody who files for defamation and loses. So it's a huge, really what the California legislature is doing is they're saying if somebody sues you for sexual harassment, you can defend yourself all you want. You can be aggressive in your defense, but don't file a counterclaim for defamation.
Yeah, Keith, I'm glad you brought that up. There's a lot of content creators that I've watched lately talking about a couple weeks ago and today, now that this Amicus briefs have come, and they've said, but wait a minute, can't Justin Baldoni defend himself against Blake Lively? How is it that these people are coming in saying he can't defend himself? And I think there's been just so much confusion about what are his rights as a defendant, and then what is the analysis if he's a plaintiff in the case. And here he's both, right?
Yeah, there's two completely different cases. So maybe we can go to the graphic. We made up the graphic here just to point this out. So there's case number one. That's the first case that Lively sued Baldoni. He's the defendant. Lively's the plaintiff.
She sued him for sexual harassment.
Correct.
So she's the plaintiff.
Yes.
He's the defendant.
Now let's say...
Wait.
Oh, yeah.
Is he allowed to defend himself in that case?
Yes.
Does 47.1 even impact him?
No.
Does this amicus curiae brief impact him in any way, shape, or form on him defending himself against sexual harassment?
No. And so if all we had is case one, we wouldn't be talking about 47.1.
Okay.
It would mean nothing to his defense to the sexual harassment claims that Lively has brought against him. And we've seen in his answer, when he has his Exhibit A to, and all of his robust responses, he has some very good factual basis,
strong evidence
for defending himself. And he has brought that forward, and it's very convincing in terms of what we've seen and the dancing video and all the various things that we've talked about over the last few months, all very strong evidence for defending himself. And he can do all of that. 47.1 does not shut him down, doesn't affect him in any way on case one.
I think it's important for us to say this one more time then, and that is when Blake Lively sued Justin Baldoni for sexual harassment, which she has done, he can vehemently, aggressively defend himself against that sexual harassment claim, and 47.1 could never touch him for defending himself against that sexual harassment claim.
Correct.
He can have his lawyers fight as hard as they can within the bounds of the law, including filing a letter with the court that the court wasn't happy about. But the point is, you can do whatever you need to do to file things or to take depositions or to do discovery. As long as you're within the bounds of what the law allows,
right,
you can vigorously defend yourself from that sexual harassment lawsuit by Blake Lively.
Yeah, and I think Baldoni has done that already. He's continuing to do that. They're scheduling depositions. They're doing discovery. All fair game in case one.
And you and I agree. Just so it's clear from us, we think the evidence is quite strong for his defense.
Yes,
from sexual harassment.
Yeah, absolutely. I mean, I think both of us have looked at that and said it's so far everything we've seen is pretty convincing.
Okay,
his case of defense of sexual harassment.
Okay. And does that mean that Blake Lively is okay? Oh,
I was just going to jump in here, and you're talking about our content creators. All our friends are here. Lauren says I walked in. They're talking about Stuart Proposition and Keith. I think I arrived at the right time.
Yeah.
Was Stuart's Musk offensive?
Yes,
inspire.
It not only it was and continues to be. Yes,
and also Zach's here too. So
hey Zach.
Oh, hey Zach.
Yeah.
So Lauren, I listened to you. If you're still hanging out, I listened to you and what's her name? The other content creator.
Oh,
Cassidy O'Connell. I listened to you guys, and I guess you were up early, so I'm glad you could join us for a few minutes. So we now have established, Keith, that Justin Baldoni, who probably has evidence supporting his position more so than Blake's side. And I'm not saying she's lying. I think she's not lying. I think she had an experience and she's filing a suit for sexual harassment. Who's going to win that? We don't know. I mean, we think Justin has stronger evidence.
Yeah.
Much stronger evidence right now. We haven't seen all the evidence, but I want to make clear he can defend himself strongly with all that evidence in court. His lawyers can show up. They can fight as hard as they want and defend. But there's a problem that got added on to this case, and that's where all these problems are flowing from. And what is that?
That's case two. And so this is the countersuit that Baldoni filed against Blake Lively for defamation. So that's a whole separate lawsuit. It's within the same lawsuit, but you can think of it as two separate lawsuits.
So he's now so he was the defendant in the sexual harassment lawsuit that Blake Lively filed. She was the plaintiff. And now we're going to switch those, and he's going to be the plaintiff
in case 2.
And he's filing a defamation lawsuit against defendant Blake Lively.
Right.
All right.
So when he's on the plaintiff side under case 2, which is the defamation lawsuit, that's where we run into problems with 47.1, because the whole point of 47.1 was to stop defamation countersuits, just like this one. Now we can talk about all the policy reasons, and we can talk about how a lot of people feel like this shouldn't apply to Blake Lively, and I get it. I understand, why that's the feeling, especially when you see how strong Baldoni's defense is. I could see why you would also feel like, well, why shouldn't he be able to sue for defamation then if his defense is so strong? And we're going to find out why. And I think it's because there's an overarching policy decision that, according to these amicus curiae briefs, it's a bigger issue than just this case. It's a bigger issue than just these parties. And that's what they're coming in to argue about.
So it seems to me that the problem for Justin Baldoni arose when Brian Friedman and crew, the lawyers over there, filed a defamation case against Blake Lively.
Yeah, the countersuit.
And I don't know whether they knew about 47.1 or not. I'm guessing they did not, because I don't think they would have filed the suit. I think they maybe they'd heard of it, but I don't think they understood the impact of it. And that's when I had said that Blake Lively's attorneys, when they filed their 12B6, did such a masterful job in pointing out, oh, this is a problem here. This is 47.1. And then Brian Friedman, in response, spent over half of his brief talking about how horrible 47.1 is. Yeah, it is horrible. It's horrible for a person who files a defamation claim against somebody who has accused them of sexual harassment. It really is awful. It's horrible because it makes it almost impossible to move forward on that particular claim.
It's bad for Baldoni for sure. And there's an old adage in the law that says bad facts make bad law. And so it is tough to see it applied in certain situations. I think this is one of those situations. And even if Baldoni did know about 47.1, I don't think it would have been knowable to know the true impact of it, because it's never been decided by a court yet. It hasn't gone up in the court system yet. This is the first case that's wrangling with it. And even when I first looked at 47.1, I thought, oh, okay, I could see what this is about. But I don't think I fully appreciated
the impact.
The impact. It's a much bigger impact than I had anticipated when I first saw it. And so I don't know that anybody could have anticipated that. But now we're seeing it really brought into focus, and people, both sides are arguing it to great effect.
So I just want to say it one more time, because we're going to kick this horse till it's completely dead. It's okay for Justin Baldoni to defend himself all day long when it comes to Blake Lively's sexual harassment lawsuit. The problem he ran into here was he filed his own lawsuit against Blake Lively in retaliation for her filing a sexual harassment claim against him, and that's his defamation claim. And once he did that, he fell into the hell of 47.1.
For case 2. And it still doesn't apply to case 1, even today. So if
he withdrew case 2,
or if it's dismissed by the court,
okay, then he can continue on with case 1
all day long.
And he can use all that good evidence that we see from Exhibit A and everything that Brian Friedman's done so far in the case.
That's right.
Okay.
Here's a question. I just want to, I'm voicing this as well. And I don't know, if it's all kind of wrapped up together and if this is possible, but Tanya Roberts asks, but what if he wins case 1? What happens with 47.1 case 2?
I mean, I think that's a great question.
What do you think?
Well, I mean, I think case 2 still goes away.
Yeah.
I mean, you have to understand the overarching policy decision here, which is the state of California says we don't want defamation countersuits. And so defend yourself, but don't countersue for defamation. So I think there's a good chance that case 2 could get dismissed by the court. But even if it isn't, it's a whole separate ballgame. And it's, again, you're going to have a hard time with this. Okay. People who are on Baldoni's side are going to have a hard time with it. I am having a hard time with it. And the reason why is because there's a broader policy issue here, and it's going to implicate this case in ways that we don't like the result. But then it's going to be good in a bunch of other cases. And, we are talking about how this kind of reminds me a little bit of the standard you need to get convicted criminally, right? To get convicted of a crime, you need to show evidence, or the prosecution needs to show evidence beyond a reasonable doubt.
Right.
That's the highest level of evidentiary standard.
Right.
Now, there's no doubt that some people get away with crimes because the prosecution can't meet beyond a reasonable doubt. So there's some people who are guilty of crimes who don't go to jail because of that.
Right.
Are we okay with that?
As a society, we are, because it's good for everybody.
Why?
Because it serves the greater good. If you are at the wrong place at the wrong time and somebody's murdered and you pick up the knife and go, "What's this?" You have the opportunity to explain to a jury that I just happened to stumble across this and pick up the knife like an idiot and look at it, and hopefully the jury believes you, and hopefully the prosecution can't prove that you were the one that actually did the murder.
So it's there to protect innocence, right? We value innocence more than allowing some people off who are guilty.
Correct.
And that's the greater good. And so I think what the Amicus Curiae briefs are saying here is something along those lines, is that there's a greater good here. It doesn't mean you have to agree with it, but that's going to be the arguments.
Let me throw an idea out to you. I mean, what if under case number 2, the court grants the 12b-6 and Blake Lively's the prevailing party and she gets her attorney's fees? Maybe she gets some treble damages. Maybe she gets some punitive damages. Maybe not. But case 1 continues.
Yes.
And a year from now, Justin Baldoni wins case 1. I think case 2 stands. And case 1, he wins. I think that's how that would work.
So he would still have to pay for attorney's fees for however much was spent before case 2 was dismissed, but he could win case 1.
Because, I mean, he could have, and I think that's the point we're making here, he could have a wonderful defense to case 1. And you and I tend to think he's got the better evidence from what we've seen.
Yeah.
And we want to see what Blake Lively has. She needs to back up her evidence. So far, they have not been able to do that. But we think he can win that. The problem is that he unfortunately filed this defamation lawsuit. And once he did that, now that's the weak part of it. That's the Achilles heel of his case. And so the opposing lawyers are going to bear down on that, and they're going to cause a lot of grief and pain for Baldoni and his lawyers. That's why I said they should dismiss it. They should dismiss case number 2 and just focus on case number 1.
What happens if the judge allows case number 2 to go forward, saying that, well, I think that there's at least enough in the pleadings that there could be malice here as an exception, so I'm going to let the case go forward. What happens? The
jury instructions are going to be crazy in this case, because if both case number 1 and 2 are heard by the same jury and they're deciding all the issues, you guys figure it out. And that may actually be the better result for Justin Baldoni than having a 12b-6 granted against him on case number 2. Because if he can get it in front of a jury and he can convince the jury he's right on case number 1, and the jury goes, God, if he's right on case number 1, he must be right on case number 2. I think that would be his better result. But still, it's such a big gamble because of the millions and millions of dollars of attorney's fees that are going to be spent in this case. And he's got to sit there, he and the other plaintiffs in the defamation case have to sit there and think for months and months and months, am I going to get hit with the attorney's fees of Blake Lively and Ryan Reynolds, or Blake Lively here? And am I going to get hit with treble damages and punitive damages?
Yeah, you're living under that risk. I mean, is it possible that a jury could decide that Baldoni wins case 1 but loses case 2?
It could.
I mean, it's possible.
It's possible.
I mean, anything's possible.
And juries, yeah, they could do it. So, Keith, let's take briefly. I do think it's important. I know Lauren and I forget the other lady's name again. I'm so sorry. Cassidy. I know they covered the Amicus Curiae brief that was filed by the individual, and that was more, anecdotal in my mind. I think it shows an example of what could happen to an individual. And I think some people have gotten caught up in, they're looking at, well, let's take a look at this individual and figure out who she really is. I mean, that's fine. You can do that. This Amicus Curiae is more of a policy, like an overall policy of the law and how it should apply to all women and men who are sexually harassed going forward. Is that right?
Yeah, that's correct.
So I did want to look, if you wouldn't mind going through the first entity here. I think these are very impressive and weighty entities that are finally this Amicus Curiae brief. Could you walk us through who this first entity is?
So this is the Equal Rights Advocates. It's a national nonprofit legal organization that advocates for gender justice in workplaces and schools across the country. And since its founding in 1974, ERA has been fighting on the front lines of social justice to protect and advance rights and opportunities for women, girls, and people of all gender identities through litigating groundbreaking legal cases on behalf of workers who have experienced civil rights violations, including sexual harassment and other forms of discrimination. ERA has also led vital policy reforms to strengthen protections against sexual harassment and other forms of harassment and discrimination in California, as well as other states and at the federal level. So this is an organization that's been around a long time and has been, in this area, whether you agree with them or not. I think that they've been doing a lot of work.
They've also participated in amicus curiae and scores of cases involving the interpretation and application of legal rules and laws affecting workers and survivors' rights and access to justice. They have a strong interest in ensuring that victims of sexual assault, sexual harassment, and other forms of harassment and discrimination remain able to exercise their right to speak freely and openly about harassment and abuse without fear of retaliation and intimidation, particularly retaliation and intimidation by perpetrators who seek to use the legal system to silence such victims.
So, as in counter lawsuits, I think is what they're getting at. And it's interesting to see these entities. These are the same entities who advocated for the passage of 47.1.
Yes.
And so it's interesting to see them come in. And
look, ERA, they co-sponsored the legislation here, which was AB 933, right?
Yeah. And then the next entity, the California Employment Lawyers Association, maybe you can walk us through that one.
So these are heavyweight hitters, and they have 1,300 California attorneys. It's a large group of lawyers, and they do CLEs, continuing legal education, and they have get-togethers. But they're a plaintiffs bar group, and they help support plaintiffs and victims of sexual harassment and sexual assault. But they're a statewide organization of 1,300 California attorneys whose members primarily represent employees in a wide range of employment cases, including actions enforcing California's law prohibiting discrimination, harassment, and retaliation in employment. They've taken a leading role in advancing and protecting the rights of California workers, including advocating for proposing legislation, as well as submitting amicus briefs and letters and appearing before the California Supreme Court, the California Appellate Courts, the Ninth Circuit Court of Appeals in employment rights cases, including numerous cases involving the interpretation of relevant employment laws. And they are also one of the co-sponsors of AB 933, which became 47.1.
Right. And then we have the California Women's Law Center. And that's a statewide nonprofit law and policy center dedicated to advancing the civil rights of women and girls. CWLC's mission is to create a more just and equitable society by breaking down barriers and advancing the potential of women and girls through impact litigation, policy advocacy, and education. And they were created in 1989, and they've placed particular emphasis on eradicating all forms of discrimination and violence against women.
So they basically put together, and they do point out one thing here, Keith, I want to ask you about. Oh, I grabbed it wrong. Let me try that again. So to their knowledge, and you just pointed this out, this court, Judge Lyman's court, will be the first to interpret this new statute 47.1.
Yeah.
And they go on and explain the broader context about victims and why it's meant to help low income and middle income people. But I underlined here that someone with the resources of Miss Lively is an aberration. And I think that's where many people are upset by this, because they're saying, wait a minute, Miss Lively is uber wealthy, apparently. She's a high paid actress. She's married to a high paid actor. She has all the advantages in life, fame. I don't know if that's an advantage these days or not, but she's got a lot of advantages that many people don't have. And so I think people are upset that 47.1 should apply to Miss Lively as it would to somebody that was low or middle income. So can you address that? What are your thoughts there?
Yeah, and I agree. I think it's harder to see how this law should apply to Blake Lively, being that she has resources. She's obviously a highly influential person. She has a lot of power. I think she had a lot of power on the movie set while all this is going on. And so I agree with that. But I think what this entity is saying is what their concern is kind of the opposite, which is, well, if we can't even protect somebody like this, then what hope is there for low to middle income people? What is a woman to do who, makes $50,000 a year and isn't a famous actress and has no power, and they are being harassed and they just want it to stop? And so you can kind of, just by looking at that language, you can figure out what the concerns are of this entity. And that's kind of what you have to do, is put yourself behind, like, why are they even doing this? Well, because they're concerned of, well, if it doesn't apply here, it won't apply anywhere. And that's their fear, I think, is that the teeth will be taken out of this law. That's how I took it. How did you read that?
Well, I mean, first I want to talk about just the overarching view of that of 47.1. So the idea behind 47.1, if we were to take a principle away from it, the people who created it, what environment did they want to create in California when it comes to this type of litigation? What were they really trying to get to?
They didn't want people to file defamation lawsuits because
In response to
sexual harassment claims, because responding to a defamation lawsuit is very expensive for the woman who's filing. It's very expensive. It's very time consuming. It's very psychologically harmful. And so they wanted to stop the defamation countersuits because, in their opinion, people were bringing them for an abusive purpose. And so they wanted it to stop.
So if you were wealthy and you were the perpetrator of the sexual harassment and the victim doesn't have a whole lot of means, you could basically litigate them into a hole to where they just have to give up.
Yeah. Right, exactly. Yeah, if you have more resources, you can out-litigate the other side.
And even worse, then you talked about this chilling effect. And so what's the chilling effect?
Oh, in the sense that if you see your friend going through this and how horrible it is, you're not going to speak up if you're being harassed because you don't want to go through that. So it's better off just to remain silent. And I think that's another policy consideration that they had.
So how do you think that women out there, and men too, but majority of women who are going to be subject to this sexual assault and sexual harassment issues that happen in our society, unfortunately, how would they view if this law did not protect Blake Lively as well?
Well, I think what the brief is getting at is that if other people, so this is their argument. If somebody who has no money and no power looks to somebody like Blake Lively who has money and power and sees that even they are not protected, then they're going to think, well, if they're not protected, what hope is there for me? And so I might as well just keep quiet. I'll keep getting harassed. I won't make a complaint, or I'll just quit and, suffer financially, because there's no point in coming forward. I'll just get destroyed in court, and I don't want to go through that.
So I think you outlined that argument very well. Do you agree with it or disagree with it?
I think 47.1 is a beneficial law. So I think I agree with it in a majority of cases. I think it does more good than harm, but you're always going to be able to point to a case where you're like, well, it didn't do good here. It's actually doing the opposite. And so I guess that brings us back to the point of what is the greater good. And just like, requiring proof beyond a reasonable doubt for criminal conviction, we decide as a society that that's better than having some other standard, because we really want to protect the innocence of people. And that's the greater good. I could come along and argue, yeah, but I'd rather put a criminal in jail and put a few innocent people in jail too. Oh, who cares? Well, you'll care when you're the innocent person going to jail. That's when you'll care. And, it could happen to you. So I like our system of beyond a reasonable doubt. So I guess on a whole, I like 47.1. It does challenge my belief in certain cases, and this is one of them where I have a harder time swallowing it, I guess.
It doesn't bother me for this case for 1 second.
Really?
Not for 1 second. And the reason it doesn't bother me is because he has evidence to support his defense.
So he can make a good defense.
He can make a good defense. And he'll look great, and he won't be handcuffed with one hand behind his back trying to fight a bunch of other lawyers because he chose the wrong vehicle to bring into this case, which was a defamation claim against Blake Lively after she had sued him for sexual harassment. And I just think it just really, and Brian Friedman wouldn't admit to this, but if he could go back in time, there would be a long discussion with his clients about, we're not sure we want to bring this defamation claim, because if 47.1 was well known and everybody knew how it applied, it just is such it's a hellhole to litigate in. It's horrible, because every time you go to try to do something, they're reminding you of it, that you have a weak claim and that you have a claim that's laying over your head and you're not going to make it through this. Whereas if you could just defend yourself in this case with Exhibit A, with the plethora of emails that look overwhelmingly in support of Justin Baldoni, you could almost just let this case litigate itself.
So
right?
Case 1 is so good. Why struggle with all the problems on Case 2? And what about the defamation lawsuit against Ryan Reynolds? Would you keep that one going forward?
Absolutely, because Ryan Reynolds allegedly said that Baldoni was a sexual predator to somebody. And if a jury believes that those are the kind of words that could damage somebody, and the fact that his I forget the name of the what's the entity that
Wayfarer?
No, the entertainment. Ari Emanuel.
WME.
Yeah, WME Ari
yeah.
Emanuel.
They did let Baldoni go after these
Yes.
comments were. Now, was it because those comments were made? That still needs to be determined. And it's not going to be somebody WME, or it's not going to be Ryan Reynolds raising their hand saying, yes, of course that happened. It's going to be a jury that has to hear that and make a determination of who's being more credible about that. But that's a good claim to move forward on.
And it's not subject to 47.1.
And the reason it's not subject to 47.1 is because Ryan Reynolds did not sue Baldoni for sexual harassment.
Right.
And as long as he didn't sue him for sexual harassment, then Baldoni can sue him. Now, there is an anti-SLAPP statute in New York that still has to be looked at, but it doesn't raise the concerns for me that 47.1 does.
Yeah. Okay. So, I mean, I think that's well put. So, in other words, go with your strengths, stay away from your weaknesses, and win this case.
Correct.
Yeah, I like it.
I'm going to ask a question. Why do you think that they did file the defamation lawsuit against Lively? Like, they're just like, hey, we think we have a good chance, like more damages. Is that why you think?
It felt good, I think. I think you're fighting. You're showing that you're not standing for this. You're saying somebody has called my reputation out, and I'm going to not only defend myself against that, but I'm going to come after you for doing that to me. And I think that there's some cases where that would be appropriate. The problem here is you can't do it. Once Blake Lively sues you for sexual harassment, don't do it. Don't file, because California is saying don't file a defamation claim in response to sexual harassment. Just don't do it.
Yeah, you can't do it in California is the answer.
Right.
But yeah, I think Baldoni wanted to strike back, and I can't blame him. I mean, anybody in Baldoni's position would want that, but it probably was not the right vehicle.
Okay, thank you. Could a judge still say that California law doesn't apply? We still haven't had a ruling on that, correct?
Keith, there's lots of, I want to ask you the question, because you've read the briefs here, and there's lots of people pointing out that California law should apply on Justin Baldoni's side in the New York Times 12b-6. You remember the 12b-6, New York law was better, and so the New York Times is arguing New York law, and Brian Friedman came out and said, it's California law. And then just a few weeks later, there was that filing for Blake Lively on her 12b-6, and that's when 47.1 first came up. And of course, there was a statement, and they're saying, Baldoni's saying California law should apply. We agree. So what are your thoughts?
The court could decide that California law doesn't apply. I think it'd be highly unlikely that the court does that, just for the reason you stated is Baldoni in his pleadings specifically argued that California law should apply when it applied to the New York Times. And so it'd be a little inconsistent to say that we were harmed because of defamation in California, because that's where we live and work, but this other defamation claim harmed us in New York. It just doesn't really make any logical sense. It doesn't flow logically.
And Brian Friedman and crew, they did a really good job, actually, when they were opposing the New York Times, pointing out why California law should apply, because they showed where the harms took place, the reputational harm. And also, aren't there a lot of California causes of action included in Baldoni's lawsuit?
That's why they wanted it, because California also recognizes things like false light and civil extortion, and those are causes of action not available in New York. So I think the court could rule that California law doesn't apply. I think it's highly unlikely that it would do that.
All right, that was a good question. Do you have anything else for us, Eric?
Yeah, there's a lot. Here's, simply put, you talked about it, but say today, could he drop that case?
He can drop case number 2, but he would be subject to the remedies that are available, which are attorney's fees and punitive damages, and also trouble damages. So there would have to be a fight. There would have to be a motion fight on, how much the prevailing party should be paid for that, and a judge would have to make that decision.
Yeah, that's right. But he could drop it today, and and go from there.
Stop the bleeding.
Yeah, I mean, it's much less attorney's fees now than it would be later. It's kind of interesting. Just before we get one more question on the brief on page 11, I think that they sum up really nicely the 2 reasons why they think that 47.1 has 2 distinct goals. It's under sub B on page 11. I just want to point this out real quick. So right at the top there. So AB 933, which ended up being Civil Code 47.1, was drafted to achieve two distinct goals. One, to shield victims from the discovery process by ensuring they would prevail at a motion to dismiss stage, and two, to remedy the financial and psychological costs of the litigation. So I think number one's kind of interesting because I didn't really think about that before. I mean, how many lawsuits would be stopped at the motion to dismiss stage because of this law, Stuart? Do you think it'd be most of them, majority? What do you think?
I mean, you're talking about the application of this particular law.
Yeah.
I think they'll be applied like an anti-SLAPP in most cases. And in the anti-SLAPP, there's a two-step analysis under California law. I'm sure other states may be different. But here, the court's going to have to take a look at 47.1 and say, was it a communication? Yes. And was it made with malice or not malice? And somebody's going to have to make that call. And some judges are going to say, I'm going to leave that for a jury to determine. Other judges are going to say, I just don't see enough here. And they're going to stop it, especially in light of the legislative intent here. And that was not to get to discovery.
So these are the two goals that these entities want to preserve.
Right.
And that's why they want to come into this case, because they don't want the court to, rule that the law is unconstitutional or disrupt these policy goals. In other words, so that's the bottom line of what they're looking for, I think.
And I suppose if you were to ask everybody that, the people that form these entities, do you support Blake Lively or Justin Baldoni? I think they'd say that's not the issue for us. The issue is we want a broad policy that protects victims of sexual harassment and sexual assault. And we believe this is the best way to get that done. And if you, the judge, don't grant this 12B6 in this particular case, in this huge case where 47.1 is first being used, there's going to be a chilling effect. And we're going to be back to square one with victims not coming forward and talking about the sexual harassment claims they may have.
So that kind of proves, why do people file amicus curiae? That was your question at the beginning. Why do they file these briefs? This kind of answers that question right there.
Yeah, these are the experts that are even more expert than the lawyers in the case. And again, if the court accepts these, I think people have talked about, well, is the court required to look at these? The court's not required to read them. The court can read them. These are persuasive at best. And there can't be any conflicts of interest. These amicus, they can't be related to the parties in any way, shape, or form. These are just people that have it's a public case, and they say, gosh, this is really going to impact the legislation we just passed. We want to make sure this judge gets it right. Let us make sure he understands, the principles here, the legislative intent, and also the broader policy issues. And if you think about it, this is interesting because this is at the district court level. This is a trial court. Most trial courts don't make policy decisions.
No.
Appellate courts, they do. And certainly Supreme Courts do make policy decisions in their rulings, right? So it is interesting that we're seeing an amicus at the trial court level. We normally don't see that.
Yeah, no, not normally.
How long does a judge have to reply? Do we have to wait until August 14th when the discovery is over?
Is that, Keith, I'm assuming that how long do they have to wait to reply to accept the amicus, or how long does the court rule on the 12B6 motions? I'm not sure which one that is, but maybe you can answer both of those.
Well, I'll answer one, you answer the other.
Okay. So I only know the answer to one of them, so I'm hoping you pick the right one that I don't know. So,
well, when it comes to first of all, these briefs have been submitted to the court with a letter motion asking the court if they can please file it. So they haven't officially been filed in the record yet. They've been filed, but not really. So the judge has to give permission to file the briefs. It just so happens that they attached copies of what they wanted to file, which is what they have to do. Before the judge grants them permission. The judge has as much time as they want. This is a federal district court judge, United States federal district court judge. They'll do it on their own time. And so there's no deadline for them to do this. So it could be tomorrow or it could be 5 months from now, but you would think it'd be relatively soon.
Yeah.
How about the 12B6?
So I know that I've read the comments and I've heard people say that we're only estate planning lawyers. And what do we know about anything? What do we know about litigation? But in the 100 or so plus federal cases that we've worked on,
yes,
what I found is what you just said. And federal judges take the time that they want. And so the 12B6s are all queued up. Discovery's ongoing. The whole idea behind 12B6s is to be that they're ruled on prior to the additional cost for discovery and everything. But right now, this judge is allowing discovery to go forward. Is that tipping his hand? I don't know. But at some point or another, he's going to come out. And it seems like the New York Times got their filing first, if I remember correctly. So we'll probably get a reveal there and kind of get some insight into how the judge analyzes this case. And then, of course, there'll be the Ryan Reynolds and the Blake Lively 12B6s after that.
These are big issues too. So I could see where the judge might want to take a little bit more time. It's a public case, make sure that he feels comfortable with whatever his ruling is going to be.
Yeah. Yeah.
Here's one I want to get to. This was at the beginning. Will this reach a civil RICO charge? Talking about the shell company and leaking the info to the New York Times.
So all 4-1 sounds. First of all, thank you for your donation. Very kind. That all goes to charity. Keith, when I saw this, I told you I saw this before the show started, and I said that I remember going to a CLE, a continuing legal education course, when I was a very young lawyer.
Yeah.
And we were talking about litigation and trust and estates. And one of the panel lawyers boasted that he was starting to bring RICO charges in his state litigation cases. And it led to one of the lawyers at the end of the table he was presenting with audibly laughing out loud. I don't know enough about RICO. Do you have any comments on RICO and how that might apply here?
Well, I don't know a ton about it. I mean, it's racketeering, and it's used commonly, I think, to take down the mob in order to show that you're involved in some sort of a criminal network. It was a way to kind of get around the fact that a lot of times you weren't able to pin a crime directly on, the mob boss or something like that. But if you're part of an overall criminal network, then you can be liable. I don't know that civil RICO charges would be filed here. I don't even know that I know enough about RICO to opine on it. But I haven't seen something like that happen in a similar situation. We've seen some similar situations. So I wouldn't think so. But that's probably about the best answer I could give. If
you were not just an estate planning lawyer, would you be able to give a better answer of that?
Well, we are trust litigators. I mean, we are litigators. We're not just estate planners. So.
Okay. All right.
This is in reference to the Amicus briefs, but JT wants to know, have you ever had one of these submitted in your cases? And if so, how did it impact your case? Or if any other public cases that this has happened in over time is my question.
I've never had that I can remember an amicus brief in any of our cases, but most of our cases are California state court cases.
Have you ever seen an amicus brief at a state court case at all?
I don't think I have. But where we see them routinely, because you and I are nerds and junkies, is we read Supreme Court opinions quite often, and we see them there. And I always enjoy, not always, but I generally do try to get to the amicus briefs because you get some insight, you get some learning there that you're not going to get in the other briefs. And so the lawyer drafted briefs. Well, amicus briefs are lawyer drafted briefs too, but the party briefs versus the non-party briefs. So I like reading the amicus, but I can't remember ever having one in one of our cases.
I feel like I've seen them attached to some California appellate court cases where people file amicus briefs. Certainly California Supreme Court cases, they file amicus briefs, but I've never seen it at a state court level, trial court level.
You know what we should do? If we don't like one of our opposing counsels, we should follow them around on their cases, and we should file amicus in their case.
Yeah,
that's what someone kind of wrote, I think, a while ago. They're like, we should all write briefs.
Yeah, why not? Yeah.
I remember somebody reached out to us a few years back and wanted us to file amicus in a particular appellate court case that ended up going up to the California Supreme Court because we had done some videos on a particular topic. And, the problem is we have day jobs. We're busy, and it was an interesting issue, but not interesting enough to have us file something.
Okay. Here, it's maybe a little touchy, but I want to get to this one. It's great that two gentlemen are back, but I was wondering if Lively's team may have extorted or blackmailed or even threatened you guys. Any contact?
I haven't heard from him.
Well, Keith, if we were being threatened and blackmailed and extorted, would we admit that? I mean,
yeah, we'd probably look a little nervous. Though,
no, we didn't do that. So no. And I see that person. I see their emoji there. So I'm assuming they're saying it tongue in cheek. No, we've not been blackmailed and we've not been extorted. I did see in the comments at one point that apparently I'm good friends with Ezra Hudson. I've never met Ezra Hudson. I've never spoken to Ezra Hudson. I do think she's a fantastic legal drafter, as well as other lawyers in this case are fantastic legal drafters as well.
Yes.
But
we've seen some great legal writing.
Yes.
We've invited both Brian Friedman and Ezra Hudson on the show. We've not heard back from either one, but we remain open. If anybody wants to talk to us, reach out.
Yes.
Here's an interesting question. If a party donates to those writing amicus briefs, are they still allowed? I think this is like getting at, if Lively's team has donated to some of these women's groups. I don't know if any of this is true, but would there be any sort of conflict of interest, and maybe the judge could like sniff this out, but I don't know.
Eric, I can't quite read this person's name. Could you read it for me out loud?
It's Don't Mess with Justice. I've actually seen this person on Twitter, so they're a active Twitter person, and we appreciate all the engagement.
Yeah, when they say a party, do they mean one of the parties to the case, like Blake Lively and Justin Baldoni?
Yeah,
No,
that's the reference.
They're not allowed to. There should be no connection between the amicus briefers and the parties to a case. And if there is, that should be looked into, and the judge would want to know that. So if anybody out there finds there's a connection between any of these briefs, amicus briefs, and the parties, we'd want to know that.
Yeah, the judge would be interested.
I'm sure people will do some digging and see if there is any connection. As we know, people will sleuth on this case. But Priya says, appreciate your opinions, frustrated by application.
Priya, thank you. You sound like a very objective person, and I know it is painful at times to hear balls and strikes being called, but thank you so much for that comment.
Yeah.
Wait, can you show this comment by Lauren? Should I put it up?
Yeah, put it up.
Yeah. Oh.
Yeah. Hey, Lauren, we have
Sounds
to,
like she's compromised.
we have to meet Lauren at some point, or
Yeah,
we got to
I know.
have her on the show again. Lauren, I like you so much. You have such an engaging personality, and anyway, would love to meet you sometime.
I'm glad somebody's getting paid for something.
Yeah, right.
Yeah. This was from a while ago. I thought this was just a nice comment from Gwen. It says, thank you so much for explaining this all in simple scenarios and terms for us to understand it all. Even though I don't agree with certain laws, at least can understand them from y'all much better. So
Yeah, that's
Thank you.
fair. That's fair. You don't have to agree with all the laws. We certainly don't.
Yeah.
There's certainly laws we don't care for, but
Gwen, thank you. I appreciate your comment.
here was a good point too from Kristen Richardson. This was a while ago, but they're saying, by the time this is over, his career is still ruined. I don't know about ruined, but it is a shame that he could be acting or auditioning for Baldoni, could be doing movies and stuff. It's kind of a shame in that matter.
I have a feeling he's going to come out of this okay. I mean, obviously, this is not pleasant to go through. I don't think it's pleasant for any of the parties. I've pointed out that every one of the parties this is painful for them. They have a hard time sleeping. They have emotional responses, just like you and I would have if we were in their shoes. But I think Justin Baldoni is going to come out of this okay. I think he'll probably, I think the majority of the public, I think, is behind him at this point in time. I would actually go see a Justin Baldoni movie right now, and I wouldn't have done that before.
that's right.
So I'd be happy.
Yeah, I
to
would
see-
actually go out of my way to make sure to watch it.
Yeah.
But it is unfortunate. I mean, that's the downside of lawsuits.
Yeah. Here, this one was from Kim earlier. 7 a.m. in Melbourne, Australia. My day is off to the best start with my two
Oh,
favorites.
nice.
Thank you, Kim. Appreciate
So
that.
sweet. Yeah, well, I think that's pretty much it for today, guys. Great show.
All right. So we almost made it an hour. Not quite, but we will be back. Thanks so much for everybody that's joining us on the jury pool. I do want to make it clear that I think that most people that are posting live in the jury pool are fantastic. And there's some people that post afterward. I think the majority of them are very good. There is a loud minority, and they do like to say certain things about you, Keith. And it makes me very angry. I stand up for you every single time I see them talk poorly about you.
I say just get in line, take a number. I mean, we're lawyers. You think we haven't heard it all by now?
So, but we do love your comments, and please engage with us. We enjoy it, and we shall probably be back in the next couple of days when something happens in the case.
I think so. It's kind of funny because it seems like everything's quiet, and all of a sudden something like this gets filed, and it's really quite interesting. But I'm sure there'll be more very soon.
All right, we'll see you guys next time. Thanks for joining us.
Take care.
We don't just talk about the law, we practice it. At Albertson and Davidson LLP, we're dedicated trust and probate litigation attorneys fighting for abused trust and will beneficiaries.
If you're facing a trust or estate dispute, visit aldablaw.com to see how we can help. And don't forget to join our jury pool by liking and subscribing. See you next time.